Hello, and welcome to this webinar on piercing the corporate veil in confiscation. My name is David Winch. I'm a chartered accountant and a director at Bartfield's Forensic Accountants. Let's get going. Today we're going to talk about piercing the corporate veil in confiscation, starting with a discussion of the case of Seager and Blatch, which laid out what we thought were clear guidelines at the time. Then talking about Mrs. Prest's divorce, and I'll explain why that's relevant when we get there. Concealment and evasion, again, will become evident when we get there. Boyle's law, the aftermath, and how we can help. Let's get cracking. What we thought we knew. Going right back to 1896, there was a key case on the separate entity that is a limited company. It's a separate legal person and it has its own assets, liabilities and legal personality. And that was decided in the case of Salomon right back in 1896. It was the case where Mr. Salomon had a business. He incorporated it in a company called Salomon Limited, and he lent money to his company as a secured creditor. Things didn't go too well, and ultimately he claimed under his security in the liquidation of the company. And the issue was, had Mr. Salomon simply set this up as a fraud, as a trick, if you like, to protect himself and use the cloak of limited liability to protect himself from creditors? Well, no, said the highest court in the land. The company did have its own separate legal existence. And that case, establishing that principle, is still good law. But over the years, there have been a number of cases where the courts have considered what's called piercing the corporate veil, going behind the separate existence of the limited company and treating the company's owners or directors possibly as if they were the company. There's a whole history of cases over the years, but I want to run right the way through to 2009 and the case of Seager and Blatch in the Court of Appeal Criminal Division. Here, the court held that the veil of incorporation may be pierced in at least 3 situations where there is impropriety and dishonesty. First, if an offender attempts to shelter behind a corporate facade or veil to hide his crime and his benefits from it. And we sometimes talk about a company being the alter ego of the director or the shareholder. In effect, the company is him. That's the sort of circumstance we're talking about here, where an offender attempts to shelter behind a corporate facade. Secondly, and this is an important one in confiscation, where an offender does acts in the name of a company which, with the necessary mens rea, constitute a criminal offence, which leads to the offender's conviction. So this was a second circumstance in which, according to Seager and Blatch, the corporate veil could be pierced. And thirdly, where a transaction or business structure constitutes simply a device or a cloak or a sham, an attempt to disguise the true nature of the transaction or structure so as to deceive third parties or the courts. So Seager and Blatch was saying that in these 3 circumstances, we could pierce the veil of incorporation. But what do we mean? What are the implications of piercing the corporate veil? Well, what it means is that the court would look at the legal substance of the arrangements and not just their form. If you like, the court would peel away the advantage which the criminals sought to obtain by using the company structure. And so in confiscation, what we're saying is that the benefit obtained by the company could be ascribed to the individual defendant. And the property belonging to the company could be ascribed to the individual defendant. Now, when we're talking about benefit, of course, benefit can be obtained jointly. So if you've, say, got a company with two directors, each of whom holds 50% of the shares, and let's assume that each of them are convicted of a criminal offence involving the company's trading, then under this understanding of the law that we had at the time, the benefit obtained by the company would be obtained jointly by each of the two directors. And the property belonging to the company would be ascribed to the individual defendants. But obviously, if the company had, let's say, £10 million turnover and £1 million worth of assets, then you might say that each of the directors in that circumstance had obtained a benefit of £10 million jointly. But of course, you wouldn't say that each of them had £1 million worth of assets. You would have to look at their shareholdings and the assets of the company. If the assets of the company are £1 million and they each own half of it, then you would say, right, each of them has £500,000 of assets in that respect. Okay, so that was the law as we understood it. And then we come to Mrs. Prest's divorce. Now, you might be a little bit puzzled as to why I'm talking about a divorce when, until now, I've been talking about confiscation, and obviously that's dealt with in the criminal courts, but bear with me on this one. Yasmin Prest made a claim following her divorce from Michael Prest on 7 properties. The legal ownership of those properties was actually held in the name of various companies, and I believe those companies were established in the British Virgin Islands. When she came to be paid out on her financial settlement on the divorce, you can imagine the conversation she might have had with her ex-husband. When do I get my money? And he might say, well, I'm sorry, I don't own these properties. They're owned by some limited companies, and I'm afraid there's no money for you. Well, she wasn't very happy with that. So she went to court, and the question for the court was the court entitled to pierce the corporate veil of those companies to ensure the satisfaction of a financial order made in the matrimonial court in favour of Mrs. Prest? There was a fair bit of money involved, and the case finished up in the Supreme Court of the UK in London. And the Supreme Court said, hey, there's no need. There's no need to pierce the corporate veil. Because when we look at the facts, the beneficial ownership of those properties actually doesn't rest with the limited companies. The beneficial owner is Mr. Prest. And so the companies are available, the properties are available to be used to pay out what's due to Mrs. Prest under the matrimonial settlement. But in the case of Prest and Petrodel Resources Limited, the Supreme Court did not stop there. What they did was they took the opportunity to talk more generally about piercing the corporate veil in English law and about whether it was something that should be encouraged and welcomed or perhaps discouraged as a general legal principle. And I think it's fair to say that they poured rather a lot of cold water on piercing the corporate veil. So what did they say? Well, they said there are 2 issues here. Firstly, concealment. And the concealment principle actually does not involve piercing the corporate veil at all. What we're saying here is that the interposition of a company so as to conceal the identity of the real actors will not deter the courts from identifying them if their identity is legally relevant. And in effect, this is what they were saying in the case of Mr. and Mrs. Prest, that the real owner of the properties in question was Mr. Prest and not the companies. And the interposition of the companies didn't alter that. So that it wasn't necessary to look at what the companies beneficially owned, because the companies did not beneficially own these properties. Mr. Prest did. So we didn't actually pierce the corporate veil. We just said the companies aren't particularly relevant. But there's a second thing that they talked about in this judgment, which is evasion. And the evasion principle is different. The court said that the court may disregard the corporate veil if there is a legal right against the person in control of the company, which exists independently of the company's involvement, and a company has been interposed so that the separate legal personality of the company would defeat the right or would frustrate its enforcement. That's a bit of a mouthful. So it's useful to talk about an example that was quoted in the judgment. The example referred to a Mr. Horn, and Mr. Horn had been the managing director of a company called the Guildford Motor Company. But he didn't own the Guildford Motor Company. He was an employee, and he was employed under a contract of employment. And one of the clauses in that contract said that if he left the company, he would not compete with it within a certain radius of miles for a certain period of time. Well, Mr. Horn did leave, and he wanted to set up within that area in competition with his former employer. Of course, he was prevented by his contract from doing that, but he found a clever way around it. He had a company formed in the name of his wife, and then he was employed by his wife's company to run a business in competition with his former employer. So what had happened here is that before that new company had been ever formed, there was a legal right existing against Mr. Horn under his contract of employment with Guildford Motor Company. And that existed independently of the new company that was formed in his wife's name. And the purpose of forming that company was to frustrate that contractual obligation of his. So the court found that in that circumstance, the corporate veil could be pierced. And the effect of that was to remove from Mr. Horn the benefit that he sought from creating that company. Now, it's rather a complicated set of circumstances, and as you can imagine, this doesn't happen very often. And the Supreme Court were quite keen to point out that true piercing of the corporate veil, such as this, is something that is going to be quite rare. Right, let's move on to confiscation. There's a case called Boyle Transport Northern Ireland Limited. I was actually instructed by the prosecution as a forensic accountant expert in that case. And we won rather handsomely in the Crown Court. And we did that relying on the principles of Seager and Blatch. But that was decided before the Prest divorce. So when the Boyle Transport case came to the Court of Appeal, they looked again at this question of piercing the corporate veil in the light of the Supreme Court decision in Prest. And they decided that Seager and Blatch really needed to be somewhat rewritten and re-understood. And what it should be understood to mean was this. In the context of criminal cases, the courts have identified at least 3 situations when a benefit obtained by a company may depending on the facts, also be treated in law by POCA as a benefit obtained by the individual criminal. So you notice things are a lot less black and white now. Now we're saying that the benefit may, depending on the facts, also be treated as a benefit obtained by the individual criminal. And I think the Court of Appeal were careful in their choice of words here. I think they meant exactly what they said. That we have to look at the facts on each case on a case-by-case basis. There were 6 points that were particularly made in the judgment in Boyle. I'm going to give you all 6 of them, but I'm particularly going to stress a couple that seem to be the most important to me. Firstly, they said the test is not simply a test of justice. That would just be too vague and unprincipled. We can't pierce the corporate veil just because we feel it or seems like the right thing to do. It's not that simple. The Crown Court, they said, needs to assess the reality of the matter, and to do so without departing from established principles relating to the separate legal status of a limited company. So it's a much more balanced view here. We're not saying Seager and Blatch, that's the decision. If that happens, then we can pierce the veil, bang, bang, bang. No, we're saying the Crown Court needs to assess the reality of the matter. And importantly, without departing from the established principles. And we're talking about the principle here of the case of Salomon, that the company has a separate legal status. The Court of Appeal reminded themselves that confiscation is not aimed to be a punishment. What confiscation is trying to do is to remove from the offender the benefit he has obtained from his offending, not to punish him. His punishment might be a sentence of imprisonment or something like that, but confiscation is not aimed at punishment, it's aimed at removing the benefit. And they said, importantly, the principles pertaining to piercing the corporate veil in confiscation are the same as those which apply in the civil courts. So the Supreme Court's decision in the case of Prest is very relevant to confiscation, even though that was a divorce case under matrimonial law, and we're talking about criminal law. And again, importantly, regard should be had to the nature and extent of the criminality involved. So not every criminal case is going to receive the identical treatment. Instead, the court, when considering whether to pierce the veil, should have regard to the nature and extent of the criminality involved. And I'll say a bit more about that in a minute. They also said, where a company is solely owned and controlled by a convicted defendant, it will not necessarily follow that the company is his alter ego. So what we accountants often refer to as a one-man company, where you have a limited company formed, it might have only one shareholder, only one director. It doesn't mean that the man is the company. The company is still there, has this separate legal existence, its separate legal rights. And we have to consider, bearing in mind these points that are raised in Boyle, whether the corporate veil can be pierced in the confiscation. So where are we? Well, where a business of a company is wholly criminal, then there's the case of Crown Prosecution Service and Jennings back in 2008 in the House of Lords, where they talked about the veil of incorporation being not so much pierced, but rudely torn away. So if you've got a business which is not a legitimate business at all, in the case of Mr. Jennings, the business was wholly fraudulent. It was a business which advertised that it could offer various financial services, there were none. It was a pure advance fee fraud. Customers were invited to send some money to cover administrative expenses, and that was the last they heard of it. They just lost their money, and Mr. Jennings and his co-defendant pocketed the money. They ran that business through a company. That company had no legitimate trade at all. And the House of Lords said, the veil of incorporation here can be rudely torn away. But aside from those very clear cases, the court now, after Boyle Transport, the court will look to the reality of the matter and the nature and the extent of the criminality involved. And the decision as to whether to pierce the corporate veil will depend very much upon the facts of the individual case. So it's no longer black and white like we thought it was under Seager and Blatch. We can't say if this, then that, as night follows day. It's going to depend on the realities of the matter and the nature and extent of the criminality as to whether the corporate veil will be pierced. For prosecutors, I think that means that they have to consider carefully whether to prosecute a company as well as its directors. Because if we think about it, suppose we've got a waste management company which hasn't cleaned up the waste that it's created. It hasn't complied with the law in terms of the handling of controlled waste and so on. And the directors are prosecuted for that. And let's suppose the company also is prosecuted. The benefit to the company is the money saved, if you could put it that way, by not doing what they're required to do in terms of cleaning up the waste. And it's going to be a straightforward matter in confiscation. If the company has been convicted, it's going to be a straightforward matter to say that is the company's benefit and get a confiscation order against the company for that benefit. Whereas if the company is not prosecuted and only the directors are prosecuted, then there's an issue, isn't there, as to what benefit they have obtained. And there was a case involving a gentleman called Powell in 2016, where it was held that Mr. Powell had not personally obtained a benefit from not incurring the expense of cleaning up, because it wasn't his expense anyway, it was his company's expense, not his. And therefore, he hadn't obtained that as benefit. He personally hadn't obtained that as benefit. The company had, and in that case, the company had not been prosecuted and the company was not subject to confiscation. So prosecutors are going to need to consider carefully at the outset, obviously, whether to prosecute the company as well as its directors. And for the defence, well, the defence should be ready where a company operates a legitimate business, albeit it may have broken some laws in conducting that legitimate business, to challenge any prosecution attempt to pierce the corporate veil. So to give an example, suppose we have a corner shop selling newspapers, sweets, tobacco, food, whatever. Let's suppose that the proprietor of that shop has incorporated the business and the business is now run by ABC Limited rather than by the proprietor. He has become a director and employee in his own of his own company in which he's a shareholder. Let's assume that he is selling tobacco and some of the tobacco he is selling is actually counterfeit cigarettes. It says Rothman's King size on them. Actually, they're not, they're fake. They are not what they are sold as. And let's say he's prosecuted for breach of trademark. He has a criminal lifestyle. He gets confiscation. What's his benefit? Is it the turnover from the sale of the cigarettes? Well, I would say, no, it's not. I would say that turnover is the turnover of the company. And I would suggest that his benefit should be calculated by looking at his remuneration from the company and looking at the proportion of company turnover which comes from the sale of the illegal cigarettes. Say it's 5% of the company's turnover is from the sale of the cigarettes. Then I would say, well, his benefit maybe should be 5% of his remuneration over that period of offending. That's going to be, of course, potentially very much less than the turnover from the sale of the counterfeit cigarettes. If, on the other hand, the company has also been prosecuted and convicted, then the company's benefit will be the turnover from the counterfeit cigarettes. There's no question of needing to pierce the corporate veil there, because we're dealing with the company's turnover, the company's benefit. So I'm saying in that sort of situation, I would be looking to argue that the corporate veil should not be pierced. Now let's imagine another circumstance. Somebody wants to import drugs into the UK. They set up a company supposedly importing broken furniture. Hidden in the broken furniture, lorry loads of broken furniture they bring in, hidden in there is the drugs. The broken furniture has no value. That business has no legitimate existence. It makes no sense. It's simply a cover for the criminal activity of importing drugs. Now, in that circumstance, I think you could say this is akin to the case in Jennings. This is a situation in which the corporate veil should be pierced. There is no legitimate trade there. It is simply a front to try and cover the illegitimate trade of importing drugs. And therefore, where there is no legitimate trade, the whole business is just a cover, then I would say, well, yes, the prosecution have a very strong case for saying we should rudely tear away the corporate veil, and the benefit of the individual convicted defendant should be the value of the drugs. Okay, so how can we help? Well, as I've said before, Bartfield's Forensic Accountants remains fully staffed, undertaking legal aid and privately funded criminal and civil forensic accountancy work. Fortunately for us, it is relatively easy for us to conduct the bulk of our work remotely using up-to-date and secure IT facilities. And we remain readily contactable by phone, email, and online. Our recently updated website is full of useful information, and of course that's accessible 24/7. You can find more on this topic on our website, and this and previous webinars can be found on the link there. In a fortnight's time, we're going to be looking at Section 16 statements in confiscation, what should be in them, how they should be challenged. In the meantime, we'll send you a free recording of this webinar. And if you've got some questions, if you could email them in, I will deal with them and get back to you. Thank you very much for your time and attention. Hope to see you in a fortnight. Thank you.